Hi Susan, thank you for joining us today.
Thank you for having me.
Wanted to know your views on what are some of the disadvantages of the existing systems for bankruptcy and insolvency in India today.
Okay. So I think if I may start, I would like to start at some definitions because I think a lot of people have confusion about the two terms insolvency and bankruptcy. It has to do with enterprise, and insolvency is actually when a borrower is starting to fail on making repayments on her dues. And at that point, the lender faces this question: is this problem with repayment something that is structural, which needs to reevaluate the entire business model, or is it something which is just a temporary liquidity crisis, right? That there is a mismatch in cash flows coming in, cash flows coming out, but given maybe a new economic environment, maybe some help in terms of refinancing, this business is a sound model. So at the point, in a good insolvency regime or a framework, what happens is that at the point when there is stress on repayment, the creditors all start asking this question: is it a temporary liquidity problem or is it a structural problem? And the structural problem is what we call bankruptcy. That no matter what happens, the borrower is unlikely to ever be able to repay the loan. In a good insolvency and bankruptcy framework, the borrower and the lender are quickly able to establish which of these two stages they are in. And this means that we quickly resolve the insolvency. Either it is a liquidity problem, temporary, or it is a bankruptcy problem, which is shut down the firm, take your assets. And this is good for not just the creditor, it's also good for the debtor. Because if you're a true entrepreneur, what you would like to do is to say, this has failed, I'm going to take my money out as much as I can recover from it. Or if there's no money, I can get a fresh start because I paid off all my creditors and I just want to start the business afresh. Okay, so it's good for both people. And the other thing that the creditors, of course, worry about a lot more is that you should be able to, when you put some money into a company and it's failed, you should be able to recover as much of that money out as possible. So in a good insolvency system, it will always be the case that there is short time to resolving the insolvency, and that the amount of money that you recover is decent. What happens in India today is that there's failure on both counts. We can see innumerable examples over the last 3 or 4 decades where firms have started, they've run into trouble because the economic environment has changed. Right? And sometimes businesses just need to shut down, but India is known to be a country where exit of a failed business is very difficult. So creditors get disenchanted. And this doesn't matter whether you're a secured creditor who's got collateral that he gave the loan against, or if you're an unsecured creditor like a family member or a friend, a well-wisher. They're able to recover money out of this failed enterprise with very small chunks. And I think that's a structural problem, and it's not good for a country where you have lots of dynamic young entrepreneurs when neither of them can get their capital out, and that's what's happening today in the system.
Okay. So then, what are some of the key recommendations of the Bankruptcy Legislative Reforms Committee that would change or hope to change the existing system?
So for that, we go back to some of the deficiencies in the current system. I think that you talk to anyone, whether it's a creditor or indeed the judiciary or the judge and the court, who are often blamed for delays in getting to resolve insolvency. One of the biggest problems is that the information about the enterprise, about the debtor, about what are the assets, what are the liabilities, that's very difficult to get at. In this new proposed bill, the bill has provisions saying that all information about the creditor's contracts, that is the liabilities, have to be registered in an information utility. So this is like saying that CIBIL has got information about your credit history. So we, in the bill, are visualizing the creation of a new industry of information utilities, where a bank will go and register the contract that they start as a loan with a debtor, and the debtor co-signs on it. So at that point, when this is happening, when everything is hunky-dory and fine, when failure comes, when stress comes, this is the information that you can present then to the court, and the judge says there's absolutely no question that this is indeed a liability. This is a due that is supposed to go to the creditor. So there is no time that's wasted on understanding what is the liability, how much is due, what are the assets, what is worth what is it worth to creditor. So that part of the problem that stalls good insolvency resolution today is taken away if we manage in the bill, through the bill, to be able to put in place an information utility which becomes part of a competitive industry, which is also regulated by what the bill proposes as a new regulator, which is the Insolvency and Bankruptcy Board of India. So that's one problem that's solved. The information asymmetry between creditors and debtors move away if you have this new industry. The second problem that we are visualizing is that world over we see that insolvency is resolved quickly and most efficiently if there is a collective process. Today in India, what happens is that some creditors have special powers. If you're a bank, the law permits you to walk into a firm and take out the asset. But on the other hand, another law allows you, the debtor, to be able to stay that process. So there's a constant tussle between the debtor and the creditor because there are multiple laws. In the proposed bill, there is going to be a single framework where if there is any instance of an insolvency, all creditors and debtor come to one table to understand what is the problem, to negotiate towards a solution. And if no one can agree on a solution, and when I say no one, I mean the majority of the creditors cannot agree on a solution to save the firm, i.e. to keep the firm as a going concern, then the automatic step within a very defined period of time is that the firm must be liquidated. Okay? And because there is so much clarity on two things. One is that's the unified law, that is, there is one legislative act under which all questions of insolvency and bankruptcy must be resolved. There is far more clarity on the part of all debtors as well as creditors when they enter into credit contracts. This also has an additional benefit that we don't often think about from the economics of the finance profession. It also gives tremendous clarity to the judge. So when the judge has only one law to worry about as opposed to 5 different laws in the country today under which he has to understand where are the powers of the debtor or the creditor, then it's much easier for the judge to come up with a judgment. And that helps to have a process where you can quickly resolve the insolvency as a liquidity problem or a bankruptcy. And once it's bankruptcy, you can quickly resolve all the issues. So I think by setting up an information utility industry as well as having a unified law, we solve a lot of the problems that we have seen in the country for insolvency resolution. Of course, there are nitty-gritty details, and I think one of the places where this law is actually quite different from any other law that we can see anywhere in the world on insolvency and bankruptcy is that not only does it specify the procedure and the rules under which these negotiations between the creditors and the debtors must take place, it also lays out provisions for these information utilities and another industry of professionals who will be the ones involved in managing the firm while the creditors and the debtor are sitting across the table and negotiating to understand whether it's an insolvency problem, that's a temporary problem, or it's a bankruptcy problem. That is, there is a structural problem in the business itself and that the firm has got to be wound down. And of course, lots of people complain about the fact that in India, insolvency is a place where you see willful defaulters. The promoters are people who get away with murder while the creditors suffer. Because you have a single law which deals with cases of insolvency for both the individual as well as the enterprise, the full case is going to be heard under one judge and under one court. That should also resolve some of the problems that we are seeing where in the country promoters appear to have a divine right to the enterprise, and that should hopefully reduce under the new code as well.
Okay.
That's a long answer.
No, but just following up. So, if this bill does become an act, do you see an immediate improvement in the situation? What are the challenges to actually seeing improvements on the ground?
So I think that there is nothing in India that can actually create immediate improvement in anything, and I think that most people would like to see immediate improvement in the quality of assets, particularly with the largest creditors that we have, which are the banks. It's not going to happen very soon now, primarily I think because of the fact that we visualize that for not just a good design of the law, but for good implementation, we need the creation of what I mentioned as two big industries. That one is the industry of information utilities, the other is an industry of professionals who will manage the firm, who will come up with solutions while the negotiation is happening between the creditor and the debtor. The other set of professionals that we require urgently is liquidators, that if the company does go into bankruptcy mode, we need professionals to manage how the assets are liquidated so that it's fairly distributed to all creditors. This is a two new industries which the bill has provided for, but which needs to be created. So it's not going to be the case that if it's enacted tomorrow, and it's not going to get enacted tomorrow. You need to have these industries in place. So hopefully, whichever is the implementing ministry that carries forward this bill to its implementation will have to worry about, in parallel, putting up these two industries in place. And I guess the final part that we need to worry about is that judges in courts, there's going to be a tribunal that is set up under Companies Act, which is called the National Companies Law Tribunal, which is going to be the place or the fora where all these insolvency and bankruptcy cases are heard with respect to firms, and the DRTs or the debt recovery tribunals are where the individuals in insolvency cases are going to be heard. The judges at these will have to adapt to a new law. They'll need to understand that the old laws are no longer in place. But so there needs to be education of judges, and in the process of resolving insolvency right now, a lot of the economic decision of whether the business is viable or not is actually left in the hands of the creditors committee. And that's somewhat of a change from the old system, where judges were given the responsibility and held accountable for coming up with the economic evaluation. That's unfair because judges are judges. They're not supposed to come up with a business evaluation. That's supposed to be with the creditors. However, that is a mindset shift for this that is required in the minds of all the judges. And I suspect that this bankruptcy and insolvency framework that has been proposed will be better implemented if we have judges who are trained with some amount of appreciation of the business decision. So we have to have these three things in place, that we have to have better working courts and better skilled judges. We have to have a new industry of insolvency professionals, and we have to have this industry that is organized of information utilities, some of which is already in place. So we have the CERSAI, we have CIBIL, we have CRILIC, which the RBI is setting up, but all of them need to be morphed, if you will, into a regulated industry called information trade. If we get all this done, yeah, we'll get some good outcomes.
Okay. Thank you so much for your comments and for explaining the situation so well.
Okay.
And thank you again for joining us today.
Thank you for having me, as I said.